Hello, and welcome to the Joss Brown Podcast. With over 40 years of combined financial planning experience serving high net worth clients, we will discuss our favorite topics, concepts, and stories. Hello, and welcome back to the Joss Brown Podcast. I'm Devin Joss, and we have
Catherine Brown.
And today we have an episode called Importance of Property Titling and Adding Beneficiaries. Mm-hmm. So two sort of estate planning topics here. Titling, beneficiaries, the fun stuff.
Yes.
So improper titling can lead to significant failures, including liens, unpaid taxes, building violations, and failure to settling loans like car loans or your mortgage. And then beneficiary mistakes, on the other hand, can lead to assets going to the wrong person or entity. It could lead to inheritance problems. Because a lot of people don't know that the beneficiary designation on an account or bank account, investment, whatever it is, will override a will.
That's right. Right.
So that's something to think about when doing your estate planning, that make sure everything is on the same page. So first we'll talk about property titling and why it's important. Do you have any scenarios you can think of how that could be messed up and cause negative consequences?
Well, a lot of times when one or another spouse passes away, they don't get around to getting to the court to update those titling things. And then when the second spouse passes away and the children have to go and clean things up, it can get messy.
Yeah.
So that's something that I've seen before. And also, if somebody has a trust that was set up and they didn't add the beneficiary, they didn't retitle the house in the name of the trust, they just got their documents done, then unknowingly that can be a mess for kids that are left behind too.
Yeah. There's two things. You have to, if you are writing a trust, there's the trust and then actually funding it with the assets that were supposed to go in that.
Absolutely.
So property titling, what is it? So there's the deed and the title. From my understanding, deed is the actual court-ordered, notarized document saying this is in your name, this house or car. And then the title is sort of the, not actual receipt, but hey, this is your rights of ownership. You are allowed to rent this out. You're allowed to transfer this. It is in your name. And if your name is not on it, then you do not have those rights.
That's right.
So the title determines who has legal rights to use it, sell it, transfer for property things. So secondly, determining how property passes at death. So this is the important part of property titling. So there's different ways, different ownerships. So it could be sole ownership, joint with rights of survivorship, tenants in common, and then you have the TOD, POD.
Absolutely.
Can you explain those two?
Absolutely. So the pay on death, transfer on death is specific to states that are allowing that, but it means that you can put a beneficiary on your house similar to what you would put on an IRA or a 401k, so that when you pass away, the house avoids probate and goes right to your heirs. So you may own a house with your spouse and then put your children as the beneficiaries on there through a transfer on death order. So that's the TOD. Something that's interesting in our state is that you can do a tenants by entirety title as well. So if you're married, instead of doing joint tenants with rights of survivorship, you can do tenants by entirety, which means that each spouse owns the house fully. And what that does is it gives you extra protection in the event of a lawsuit or a liability that might come against one spouse or the other, and the house would be protected. So let's say you got in a car accident and were sued for $1 million, and you owned your house with your wife, tenants by entirety, then the house would be safe because it's owned entirely by your wife and by you. So
how is that different than joint with rights of survivorship?
So in that same lawsuit, half of the house would be up for grabs.
Okay.
Yes.
Gotcha. Because I know with joint title with rights of survivorship, that's a lot of words, that passes to the co-owner automatically, and that is 50-50 ownership, right?
Right, if you pass away.
If it's two people, it's equal. Whereas we mentioned tenants in common, that could be unequal shares.
Yes.
I believe. And then let's say you and I owned a house, you own 60, I own 40% of it, and if I pass away, then my 40% goes to my heirs or beneficiaries.
Right, exactly.
Yeah.
Exactly.
So just a little bit going into that estate planning, not super in depth, but just the idea of why that's important. It's also important because it affects taxes. When someone passes away, there could be a step up in basis, but if it's not titled properly, that might not occur.
Absolutely. The step up's important, and so is the capital gain exemption, right? So, for example, if you owned a house with a spouse and that spouse passed away and the title was joint tenants with rights of survivorship and they owned half of it, and then you went and sold the house and within the 5-year, 2-year rule where you lived in it 2 out of 5 years, you would only be able to take the exemption for your half.
Yeah.
So that's important too when you're thinking about the titling and how all the ownership goes there.
Yeah. It could. I guess what we're trying to say is these things could cost real dollars.
Absolutely.
If done improperly. So there's tax consequences. We like to say that we have a knowledge on taxes and like tax planning, but we are not tax experts. So we definitely work with a tax professional when dealing with client situations, as well as their attorney when it's with estate situations.
Absolutely.
Then lastly, the consequences for improper titling could be if you're dealing with a lawsuit or a divorce and things are titled, let's say in one of the person's names and they're getting a divorce, how does that affect the divorce if it's not in the other person's name?
Yeah, so I'll give you an example. Sometimes people inherit houses from their families and they may be the only one on the house and then they get married. If they never put their spouse on the house, then go and get divorced, it may be considered premarital property. And so it would be sheltered from the divorce settlement and all of the house would belong to the original owner. But if the spouse went ahead and changed the title and put the husband or the wife on with them, then it would be now marital property, right? And so then it would be fair game in a divorce. So that titling is really important at that point.
So for divorces, it's important. For lawsuits, like you mentioned the car crash earlier, and then death. Let's say you have the TOD for your son in the scenario, but your son has moved on, doesn't talk to you, and you actually wanted it to go to your other son.
Yes.
Or split different, however you wanted it to go. You updated your will, that's how it was done, but you had the TOD as the first son. So there's just different inheritance things that could happen, and if you pass away, it might go to something that you didn't want to.
Exactly. And so you want to make sure to look at those every year, the beneficiaries for the house and the titling for the house, and make sure that it's still what you want. So the nice thing about transfer on death is you can change it at any time and redo who you want the house to go to in a title.
Yeah. So we'd say to check those or update them maybe when you have kids, when you get married, or if someone passes away, then to keep those updated. But definitely look at them every year or every couple of years.
Absolutely.
Is there anything you wanted to add on the titling before beneficiaries?
Well, I would just say we talk a lot about houses, but titles also apply to cars too. So you can put a beneficiary on your car as well. and that way that it can avoid probate and go directly to who you want. And the same titling, joint tenants or sole ownership would apply for automobiles as well.
Mm-hmm. All right, beneficiaries. What is a beneficiary, and maybe even a contingent beneficiary?
Somebody getting a benefit.
There you go. We're done the episode.
Yes.
So the beneficiary is the person or entity,
Mm-hmm.
like we mentioned, a trust
Mm-hmm.
or even a charity.
Mm-hmm.
So if you pass away, then the benefit goes to that beneficiary. Then the contingent beneficiary is if that primary beneficiary has passed away. So you have multiple options.
Yes.
But there could be also multiple primary beneficiaries. So
Yes.
you can split that up.
Yes, so the primary is the first. And the contingent is important as well, because if Devin and I were traveling together and he was my beneficiary and we both passed, then we want a backup, and that would be the contingent.
Yep. What happens if the contingent has passed as well?
Oh, no.
The state did something with that?
Then we have to go according to the laws of the state or the laws of your will, if you have a will in place.
Mm-hmm. So let's see, where do beneficiary designations apply? Where can I put them?
I guess one would be a bank account, right?
Mm-hmm.
So you can put a transfer on death on a bank account, or you can leave it so that there's no beneficiary on a bank account, but then it would go through probate.
Yep.
A retirement account like a 401k or a 403b or a thrift savings plan would also be something that you can put a beneficiary and a contingent beneficiary on. And then we know life insurance, right? So
that's a must on
that's
that.
A must, yes.
On that one.
So.
Yeah. We do see beneficiaries not on accounts more often than we'd like.
Yes.
It's very important when you open up that bank account or investment account. I'm pretty sure it's on most of the first steps to do is to add a beneficiary.
Yes.
So definitely check your bank accounts, investments, your insurance policies for beneficiaries. And so what are some common mistakes if the beneficiaries are not up to date or not on there at all? I guess we kind of talked about that with titling, but it's a little different.
Yeah, the most common mistake I see is the beneficiaries that were listed are no longer living. So a lot of people put their parents or friends or aunts or uncles, and they may not actually exist anymore. They may be moved on. Another mistake I see is just delaying doing that part because it's optional. Like you said, when you open the account, you can skip it. And let's see, can you think of anything else that maybe you've seen?
I haven't seen these, but I've heard like the unintended heir thing.
Yes.
Like if you're really close to your mom or dad on their deathbed, and they're like, "You're gonna get this because it's in the will," and it's in the will, but the beneficiary is for something else, and you might not be a beneficiary. Then that's a common mistake. Minor children, I have this on here.
Oh, yes.
Having a minor child as a beneficiary could lead to some consequences if there's no provision. Let's say for a trust, sometimes they wouldn't have access to the money until they're 30 or 35 or 40. But if they're 20 and you pass away and they get access to, let's say, millions of dollars, that might not be the wisest way to steward the wealth.
Absolutely. I've also seen people list their children as beneficiaries, and I've seen the downside of that, where a child inherits a lot of wealth without a guardian in charge of that money on the listing. And so, the money can be held up in court until they're 18 and can really eat up expenses from attorney fees and stuff like that, rather than going to benefit the child. So if you do list a minor child as a beneficiary, you may want to consider listing it as an UTMA, UGMA, right? and then listing the guardian as well, so that right away somebody has control of that money and it's not held up until they're 18.
Yeah, that's definitely a wise decision.
Yeah.
One thing I have seen is for marriages, where people might still have their siblings as beneficiaries,
Yes.
or a parent or whoever, and fail to change that, which you can go in and change it, but we've just seen that and helped them update that. But yeah, I think that's kind of the main importance of these things. Just practical tips here is to review your assets and beneficiary designations regularly, which you mentioned, maybe every year, a couple of years, and then coordinate that with your estate plan. So make sure your will and your beneficiaries and your titling is all the same people,
right?
If that makes sense. Work with an advisor or an attorney. Definitely need an attorney for your estate plan. I guess you could go online and make that, but we would not. I guess it depends on the person.
Yes.
But yeah, those are the practical tips. We hope you like this episode, and be back for more. Thank you.
All right, thank you.
Thank you for tuning in to today's episode of the Joss Brown Podcast. If you'd like to see more episodes, visit our website at jossbrown.com.